preparing my presentations is I chose nice calming backgrounds, right? So if you start to feel anxious about something when we're talking about, just focus on the background and don't think about the stress and pressure as we are moving forward. Okay, let's see. Let me figure out our little remote here. I think it's on. Maybe not. Did it close? Okay. All right. Well, forget it. Okay. So we'll get to that in a minute. The concept for today is basically to just kind of have a little bit of fun with some of the unusual scenarios that we all face from time to time in a closing. And to and that would not be my next one. So it was pretty though and soothing. So do look at that. Here we go. Um, First is there is no shame, right? Because one of the things I want to talk about today is even though maybe when you're looking at something in hindsight, and everything I'm going to talk about today is a true actual fact pattern that some of our agents, and sometimes more than one of our agents, have been in the middle of. So, but my point is this: we all get there. So I don't throw stones. This is not my attempt to try to embarrass anyone or single anyone out. My thought was this: let's talk about some of these things and I can share solutions and maybe talk about what may or may not possibly have been, should have been done and wasn't done. But it's again the idea that instead of feeling bad, instead of thinking that this is scary and I don't want to do this anymore, let's think about the fact that really honestly, in my world, ethical dilemmas are not black and white, and the solutions are not black and white. It's all gray, right? So there's not necessarily a right or wrong answer for some of these things. It's what we do that helps us sleep at night, right? So that's how we're gonna consider this. So again, so my nice calming background, right? All right, so the first scenario that I thought of when I wanted to talk about this presentation is one that I'm fairly positive, again, if we were all drinking, when I asked this next scenario, everyone in here would have to drink. And that's the concept of multiple settlement statements, multiple versions of a settlement statement, okay? So consider this. You have a realtor that says that the seller is going to give the buyer some cash to address some repairs that need to be done, but they're going to handle it outside of the closing, right? And is there a way you could just prepare one settlement statement that shows the payment, right? But then just do another one for the lender, right? Because we don't want the lender to know about this under the table money, right? Yeah. Okay. Right? No, that's not a problem at all, correct? No. No. Okay. So, what would possibly be the risks here if you do that? Hmm? Okay. Well, how about your business reputation, right? If it gets around that you are willing to have multiple versions of a settlement statement, that might not be the best reputation that you want to have. Um, you might suffer from some loan fraud allegations, especially if the lender subsequently finds out that that happened. And obviously that could have a direct impact on your preferred status with lender. And right now, you're certainly not wanting to give up business, right? You want to keep all the business you have and gain more. You also might not know this, but you could run afoul of having the FBI show up to investigate. Now, I will tell you that you have no idea what it's like to get the call from the front desk to tell you that there are FBI agents there to see you. It's not a good feeling. And you immediately freeze, lose all color in your face, and think, oh, dear God, what did I do? What did I do? That happens to me, and Tron was not in the office that day. So I get the call because the poor lady at the reception, and they didn't specifically show up and ask for me. I didn't know this until later, but they showed up, and her first thought was, well, let's just let Stacy handle it. So, yay me. So I show up, and the two gentlemen are at the front desk, and they're of course armed and dangerous, and have their badges, and they're like, "Can we speak to you privately?" And I was really wanting to say no, but of course, absolutely, follow me. We go in the conference room. And they were there because an agent that was under investigation for loan fraud and that They needed to know what we knew about it. And they needed to know what if we had copies of documents and they were trying to build a case. Again, this wasn't something I wanted to be involved in, and I don't want to do anything that would potentially damage an agent, but it's the FBI. And so I promptly had to step out and contact our internal litigation team to say, help, what do I do? And they took it from there. It's, it's amazing to me sometimes. I think we do so much and we go so fast that I think sometimes we get a little bit of tunnel vision and we don't realize how many people can actually overview and see what we do. And that's, I think, unfortunately what happened in that particular case. I would love to tell you that that's the only time that I've had the FBI show up, but it's not. And in the course of the 18 years that I've been with the company, unfortunately, we have had more than one agent, unfortunately, run afoul of problems, let's say, that get the FBI involved. And generally, I will tell you, it comes because of a lender getting upset and a lender finding out that there are some potential loan frauds, some potential issues, and they prompt a call to the financial crimes division. And then that is ultimately when the FBI tends to take a peek. So, on top of that, though, I will also tell you that when I was a closing agent, my father-in-law was a big-time realtor in the city of Memphis and had been for a long time, obviously well before I came on the scene. And he was getting close to his retirement stage, and so he didn't have as many deals as he used to. By my choice, he was not out, turning and burning at this point in time, but he had a few. And as most realtors are, whatever he had was his precious, right? And it's going to close because he's going to get his commission check. And he had that exact fact pattern. There needed some repairs. They wanted him to get that money to get the closing to go through, and they wanted me to do that. And I had actually only been doing real estate closings for about a year and a half when this situation came up. And this is my father-in-law, who I dearly loved, and I just lost him this year. And I wanted to make him happy, but I'm stuck because I've been to training like this, and I had been to CLEs, and I knew I couldn't do that. I could not do what he was asking me to do. And that feeling of being stuck in that situation is a terrible one. So I went to my underwriter at the time and said, what can I do? What are my options? Is there a way that I can accomplish what everyone wants that doesn't run afoul of this? And they helped me brainstorm. And I can't tell you that our ultimate solution made everybody happy, but I was able to get everyone to finally understand why I couldn't do what they wanted me to do. And they then worked between them. And what ultimately ended up happening was there was some reduction in some of the commission between the agents in order to be able to make things work. But it didn't alter my settlement statement. And it wasn't rising to the level of the loan fraud the way the original plan was. So a point in bringing up this conversation is that there is almost always a viable option. But when we're in the heat of it, and it's your father-in-law or your brother or sister, and you've got an emotional connection to the people that are asking you to take an action that you shouldn't take a breath, step back, and reach out to, if it's your underwriter or if you've got a business partner or if you've got anyone who's got that level head that can help you take a minute, step out of that moment and brainstorm. What else can I do? Because at the end of the day, right, we're customer service. We are customer service. We are dependent on making our customers happy to keep their business, grow our business. So having to say no is really difficult and it's challenging. And it's easy when we're in these seminars where we've got the hindsight of 2020 vision to be able to pick out the moment when you could have made a different choice, right? So that's why I said when I do these presentations, I'm not trying to call you out. And if you have done that, you are not alone. And it doesn't mean that you have done anything wrong per se, because again, you have to weigh out all the risks. You have to take into consideration all the factors, and you have to determine if doing this possibly incorrect step is worth the risk and worth the potential impacts. And you have to be able to analyze what those may be. All right. Are we ready for a drink yet? Since this is our virtual drink, okay? Since we're not going to take fireball shots. Okay. At least not yet. All right. So my next scenario, and again, these would be ones that I'm quite positive everyone has seen at least once. So title of the property is held by husband and wife. Husband has disappeared. And wife needs to sell and move to a new start. So our first version of this, and again, remember, these are all actual fact patterns that we have had agents call and be involved in. Husband is in prison for domestic abuse. Wife wants to sign to sell the property, move away, and they don't want him to know anything about it. So they want to do this without getting his signature, okay? Now, remember I said the title is in husband and wife. He is on title, okay? There are public policy reasons why you want to do this, right? Okay, so, but what's the impact, right? Because the buyer is now going to get a title signed only by one spouse. And when they go to put a mortgage on later on or refinance, or they themselves go to sell and you guys get the title work, what's the first thing you're going to notice? What happened to the other owner, right? The other spouse didn't sign. And there's not going to be anything in the chain of title to explain that. You're going to start thinking, well, did he die? What's going on? And then what if then you find him and he goes, no, I didn't know it was being sold. Where's my money? And yeah, I mean, it's a risk, right? But your initial feeling, your initial impulse is going to be you want to help, right? It's a terrible situation. So what do? Right? What do? You have to start that whole thought-provoking, like, what are we going to do? Let's brainstorm on this because you want to help. Okay, so what if their property has a pretty big mortgage on it, right? So what if when they sell, she's not going to net a whole lot? What if she's only going to get like $8,000, right? And all she wants is to end her attachment to this place and get the heck out of Dodge. She's going to make $8,000. So arguably, had he been involved, what would he get, right? Half of that, potentially, right? Well, what if also once she sells this property and gets that $8,000 and moves to greener pastures, she's going to start divorce proceedings, okay? So maybe if that's the case and she does her divorce proceeding and she is able to address that at that point in time, maybe, but again, by the time she does the divorce proceedings, right, she's already sold the property, so she doesn't have it. It wouldn't be a marital asset anymore. But you start thinking along that track, right? What could we do? Why isn't she currently filing for divorce? Okay, let's go through that. Why isn't that already on the table? And kind of get more information. The whole point of all this is to say, okay, your initial question when they first ask you is you're going to want to say, okay, what can we do? Yes, yeah, of course, or no, I can't do that. But instead of giving that response, let's start going through all the different facts. What are all those details? What can we find out that maybe helps us find a solution that gets her the closing and gets her gone, but eliminates the risk to the title and obviously to you and then to our insured with respect to the lack of his signature? What does she think he's going to learn? Possibly, if you get his signature, all he's going to know is they're selling the property, right? If it's that she doesn't want him to have any of the money, well, put the money in the account, file the divorce proceeding, and make a pitch that money should be yours, right? But maybe she's not thinking through those things. Okay, so that's some of the way to work through it without the risk, right? What about scenario B? Wife is on drugs and has disappeared into the homeless community. And but they just want to go ahead and complete this without her signature. It's the same kind of thing, right? Okay. What's funny to me in the South is over and over and over again, we get these scenarios where they're married, they haven't seen each other in 20 years. And inevitably, they have no idea where he or she is. They haven't spoken. And I don't care that she was in title. I've lived here for 20 years. I'm selling this and let's just get it done, right? What I find funny is when we at the title company say, sorry, that's not going to fly. And even more so for our folks here in Arkansas when you're dealing with dower and curtsy, right? Yeah, you got to find missing spouse. I'm going to tell you that about 60 to 70% of the time when we draw that line in the sand, amazingly enough, suddenly they can find them. They know exactly where they are. I also find it very funny that we get those calls sometimes and they're like, we have no idea. And we can go on Facebook, we can go on Instagram, we can go, heck, fire, you can go on Google most of the time and you can find these people pretty quick. You mean this person? Looks to me like they're right down the street in Little Rock, but I don't know. So yeah, again, practically speaking, it's not going to be easy to find wife in this scenario, right? So, okay, what are your other options? File for divorce. I don't get what the stigma. I mean, maybe it was a big deal 20 plus years ago that you were a divorcee, but if it keeps you from doing what you need to do, get it done. Get it done. And then petition the court to divest her out of her interest, invested in you. Please, dear God, if you do that, put the direct description of the property in the order. Please, 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 please. Okay. And for all of my friends that are watching on Zoom, I apologize. I keep hitting the mic, so sorry about that. Okay. Final scenario here. Husband has mental health struggles and has disappeared under circumstances that suggest suicide. This particular fact pattern, his car was found by the Mississippi River. He is missing. He is presumed to have thrown himself into the river, but his body has never been found. And it's been, at this point in time, about 6 months from that point when we're first approached about wanting to sell the property. Title was vested in both. If he's not dead, he's still in title. What do you do? What do you do? Right? Because you want to help. The family wants a fresh start. They want to get out of this house, move to someplace else. What do you do? He's not been legally declared dead and he won't be for a number of years, right? What are their options? Well, maybe she can't sell. Maybe she can. So maybe we have to look at walking her through some other options, right? So the other thing that I talk about when I do ethics presentations is the fact that when you have customers that come to you for your closings, whether they're selling, whether they're buying, or even when they're putting a mortgage on for a refinance, you are the expert. You are the one with all the knowledge. They are coming to you and relying on you to be their expert in a field they don't know anything about. So this is a chance for you, even though maybe this particular closing can't happen the way we were anticipating. What if maybe you have to do some sort of a lease situation? You still do a closing, right? But maybe you have to do a lease. And maybe in that scenario, the title company might be willing to take that risk on versus a straightforward sale when we know there's an interest outstanding, right? So again, it's the concept of taking a moment and trying to figure out what other alternative options might be out there because it's one thing to take care of her side of the situation, but you also have a purchaser who's taking title that you have to keep in mind the impact these actions have for them as well. True scenario, we are driving here on Wednesday and I get a call from an agent. Agent says the following: working on a closing, and originally the lender told me that title was going to be held by a mother and daughter. The reason is because daughter doesn't have the best credit. Daughter is buying a house. And oh, by the way, daughter's husband is probably not here legally and doesn't have any documentation. So they don't want husband to be entitled for obvious reasons. So mom is going to co-sign and all is well, except that daughter apparently has really, really bad credit. And now the lender has decided internally they don't want daughter on the title either. So mom's going to buy the property and mom's going to sign that it's going to be her principal place of residence. But mom has a house already in the same town there where mom lives with mom's severely disabled husband, who mom does not have power of attorney nor conservatorship over. The call was because the agent was frustrated that the lender was ignoring the fact that the spouse was going to need to sign because she is married and she is now taking title to this property. And they're of the position, no, he doesn't have to sign anything. He's not going to be entitled to purchase money mortgage. He doesn't need to sign. What startled me a little bit about it was the fact that it's loan fraud, right? He was so concerned about the issue with the spouse not signing and this disabled spouse not being able to sign anything. He didn't notice the fact that he was being asked by the lender to commit loan fraud. Mom was not going to live in this house. It's not going to be mom's principal place of residence. And the thing that jumped out to me about that, and the reason I wanted to include it today, it's not on my slide because it's fresh, hot off the presses, okay? But my thought was this, right? There were a lot of issues going on there. And I'm not saying the one he was focused on wasn't important, but a lot of times when a lender asks us to do something, we're not talking to the lender with a capital L, right? We're not talking to the representative for, give me a bank, I don't know, in South, right? We're talking to the local loan broker, and that's who's giving you that instruction. They don't speak for the company the way you think they might, right? So if that were to go south, and I already mentioned that we've got a husband that might not be here legally, and we all know what's been going on with those kind of folks. So let's just say that for some reason this loan comes under scrutiny. You're taking a real risk when you do something like this based on the fact that the lender told you to do it. But what choice do we have, right? That's our source of business. That's where our bread and butter is coming from, right? So closing instruction letters, right? The things that the lender sends us, you make sure you keep those, right? You document that for your file, for your own protection. And we're going to talk about in a minute how strong those CYA documentations may or may not be. But yeah, that's how you protect yourself. And then with respect to your client, again, you got to go through that analysis, right? I'm being asked to do something I know is not necessarily proper, but what is the outcome? What's the full risk? Is it worth it? And if it's not worth it, what other steps might I take to make it potentially be something that works for everyone? Maybe not the way they initially asked us to, but it still gets us where we need to be. Everybody's marginally happy. And, there you go. So, all right, moving on. Another nice soothing view, little beach time, we're not going to be nervous about all this. I also find it somewhat humorous that, or I shouldn't say humorous, maybe I should say startling. There's a reason why the board or the bar for every state has a substance abuse program, because the stress that we are all under with what we do drives us to drink. Again, why I thought it was appropriate to base my whole presentation off a drinking game. Okay, so there you go. All right. Scenario number 3. You are working a split closing and you represent the seller. Your office will be issuing the owner's policy. As you're working on the closing, the seller casually mentions to your staff that he and the neighbor have become increasingly angry with each other. And he's glad that he's going to be moving away, seeing as the neighbor has decided to start a lawsuit to require that the garage and outdoor kitchen that he built that encroach over the property line be torn down. Okay. But don't say anything to the buyer side about this, okay? Because I don't want to lose my sale. All right. Of course, that's not a problem, right? You represent the seller, right? That's where your loyalty is, right? That's who you got it. Yeah. Not as clear cut as we would like it to be. So do you have ethical obligations to the buyer because of the owner's policy they're going to issue? I don't know. My gut reaction would be to say, yes, I think you do, especially if you're preparing the deed, right, to this person that's going to take title. You have knowledge that would have a direct impact on the title that this buyer is getting, right? They're about to buy a lawsuit. Now, if you're lucky, buyer's going to get a survey. The survey is going to show this encroachment. That knowledge doesn't come from you, right? It's going to show up in the survey. So could you maybe subtly suggest, so-and-so down the street's doing a special on surveys right now. You might want to just go ahead and get one. It's always best to get a survey. Depends on how close you are with the side closing for the buyer. What would the impact be if you sit on that information and then it comes out that right? I mean, you're risking your future business with the realtor on the other side, the lender on the other side that you may also do business with, right? I mean, there are a lot of folks that may get royally upset that you have this information and you withheld it. Now, how's it going to get out? Guess it depends on who all was around when that conversation happened, right? How well you trust your staff to keep their mouth shut. I don't know. The likelihood is that these neighbors are not friendly. It's not a secret, right? And so it's probably something that's going to be out and about. Concept is this: you have to keep that in consideration. You have to think all these things through, and all with knowing all of the people that are involved that are going to be upset if you don't get it done, right? So it's always interesting to me when we're doing these split closings, which honestly, that's kind of universal at this point in time. I don't have a single state that I represent that there aren't split closings that take place. And it does put both sides in, and can I say, put them into this awkward situation where you have knowledge, however you came about that knowledge, that the other side needs to know about, and how does that get distributed? Say, for example, the other side of this. You're working a split closing and you represent the buyer. The seller side has got information that impacts it, and they have shared it with you. And they say that there is a missing heir that will not be signing that holds 25% interest. The family is very dysfunctional, because when is there not a dysfunctional family in what we do these days? And has no intention of trying to find this fourth child. And they just plan to split the sales proceeds 3 ways. Now, the title company, not surprisingly, has said, yeah, we're not going to insure that. You got to have the fourth signature. We're not going to insure that. What do you think the first thing is that comes out, right? You're representing the buyer. You share this information with the buyer. What does the buyer say? I don't care. I want the property. I'll just take an exception for it. You just put that in that policy, right? Doesn't matter to me. Okay, can you do that? I mean, the title company may be willing to issue a policy that takes exception to the interest that's withheld from that particular person, right? We might be willing to do that. But does the buyer really know what that means? I think that's when you have to have that little moment to step back and say, okay, somebody, realtor, I'm looking at you, has told them that this can go through because the insurance company will just take an exception. That's where that comes from. Remember I said earlier, they come to you because you're the expert, right? So you have to have that conversation with the buyer to say, okay, well, listen, here's the thing. Because in a scenario where you've got a missing heir, That missing heir being somebody that has disassociated themselves with a family. You've got a dysfunctional family. When somebody dies, what's the first thing that happens? Typically, this dysfunctional family and the missing heir, they will stay that way until they smell money, right? And then they come back home, and most of the time they have found Jesus. And Jesus wanted them to come home and just back into the arms of the family and cure all of that pain and suffering. And oh, by the way, where's my check? Right? So it's all well and good that the sellers have told the buyer through their realtors or even face to face, you don't have a thing to worry about. He's been gone 20 years. Nobody knows where he is, right? Because nobody bothers to look for him on Facebook, Snapchat, Instagram, or whatever it is. Okay. Yeah. I mean, that's the thing. So they need to have that conversation with someone who's going to be honest and say, okay, we may be able to willing to do this, but here's what you need to know. Because if that person shows up and we issued a policy with that exception and they're knocking on your door for their 25% interest, who's writing the check? You are, right? Buyer is, not you per se. Well, Blake is. Blake's going to write the check. So you have to have that conversation with them. You have to make sure that they actually understand the risk that they're willing to take. What's that monetary value? And the other thing is too, it's all well and good that they're willing to take the exception, right? But if it's not a cash deal and they've got a lender, will the lender take the exception? No, the lender will not take the exception. So now they're running the risk that they possibly could lose their loan, right? So the impact of their, I'll take it, I don't care, gets less as they start understanding what the risks are that they're having to take. And then let's say you get through that conversation and the buyer says, okay, well, I'm buying this for, I don't know, $100,000. So my 25% risk at max would be $25,000. My aunt left me some money. So I'm going to put that into a savings account and it'll just sit there. And when does their interest, when do I not have to worry about it anymore? Well, never, right? They will always have to worry about it. There's not a statute of limitations per se. Now you might have some adverse possession things. You know, again, you got to go through this discussion with them about what their true risk is. And then how do you document that? How do you document that you've had that conversation and you have made them understand what the risk is, and then they willingly decided to take that risk? So if you have that CYA form, right, you got to make sure it's really specific. Because inevitably, no matter how much they tell you that they understand and they want to take that risk, when it blows up, and it almost always does, when it blows up, they are the first people in line to say, that is not what they told me. That is not what I understood. They said, so you got to be specific in that stuff, right? You got to, and let's be honest, Kimberly was being kind of tongue in cheek on the stellar litigation experience that I had. I had a very, very, very brief stint as a litigator when I first got out of law school. And it did not take me very long at all to realize that I am an anti-confrontational person. And being on the defense side in litigation means I was having to be in confrontation all the time. And I didn't sleep well. It was not a good fit for me. My Ally McBeal dreams went up in smoke, and I realized I needed to get out of being a litigator. So instead, I thought, okay, I'll go investigate the other areas of law, see what I like, and stumbled across real estate closings. And I thought, oh my gosh, this is a perfect fit for me. Everybody's going to be so happy. I'm going to go into these closings. They're going to sell the house they hate, buy the house they love. This is epic. This is so where I need to be. That lasted a month. Yeah. So obviously that is not the case, but my point with all of that is that it doesn't matter how happy they are at the closing table, right? If something goes wrong, their immediate reaction is anger, and it's pointing right at you, right? How could you let me go through this and not tell me? Even when it's something you had no way you could have ever found out, right? They're still mad at you, and you got to figure out a way to make them happy. So when, so there are always going to be ways we can figure out a situation, we can take a risk on. The steps that we take when we're underwriting, the analysis that we do is, one of the first things we always look at is what's it going to cost? If we're going to take a risk, what's it going to cost? Right? So you kind of have to do the same thing when you're in that scenario, right? Okay, if we're going to make them happy and we're going to make this deal work, if everything blows up, what's it going to cost? What's the damage? If it's just $10,000, okay, maybe I've got $10,000. I don't, but maybe you do, and you'd be okay with that risk. You have to quantify it, right? And you really, truly have to make sure that all the parties that are involved get it, understand it. Nobody's being snowed. Nobody's is being left out of the decision making, and you document it. Worst case scenario, that documentation may not necessarily be worth the paper it's written on, but it helps you start to build a defense if and when everything goes wrong. And your client may or may not know that ignorance is not a defense. So, but you still would have to build that case too, right? So, fun, right? Isn't this great? Don't you love this topic? Okay. All right. This is the last time I'm doing ethics for you, Kimberly. Okay. So, all right. Next topic. Okay. So one of my faves. Not. All right. Your office is handling a 1031 exchange for the seller. The exchange agent reaches out to ask that the statement be revised to include a payment to a third party. During the discussion with the exchange agent, she mentions that this payment is a way for the seller to get reimbursed for some of its expenses. Neither you nor your staff know much about 1031 exchanges. Okay to follow the agent's directive? Okay, so if you've not had the pleasure of working on a 1031 exchange, basically one thing I can tell you about a 1031 is the whole point is that the party whose property is being sold cannot touch any of the funds in order to benefit from the tax abatement benefits of the 1031. Now, another joke that I have probably told some of you more than once in here is the fact that I went to law school partly because I didn't want to do anything involving math. Math is not my love, okay? So I certainly did not take the tax law class because there would be math involved in that, or so I thought. So I am not a tax expert. I do not play one on TV. I don't want to be a tax expert. I know enough to be dangerous. I will say, obviously, when you are asked to do something that seems a little unusual with your 1031 tax exchange, you should probably first be concerned about tax fraud risks. You may or may not have a duty to discuss with your client how much you do or don't know about 1031 exchanges. You don't necessarily have to say that, but what you might say is, hey, do you have an accountant? Because you might want to talk to your accountant about whether this is something you should do or not. I think most of us in here have some sort of statement in some of our closing documents about the fact that we are not taking on any taxable consequences of what our transactions are. Maybe you have it in your CFA form that you have signed. I say I think you should if you don't. These are things you have to think about when it comes to that, right? Because again, they expect you to be the expert and they may think that you're the expert about all of this. And as we've just been discussing, those CYA forms may or may not protect you. 1031s are becoming more and more prevalent. If you haven't had one yet, you probably will before the next couple of years are over with. They're excellent in providing services to your customer, but there are tons and tons of tax legislation entailed in all that Kyle knows all about. So you can call Kyle for your 1031 exchange. No. My point is this: whenever we're doing a closing, whether it's a 1031 exchange or some other very strange, obscure tax benefit or tax credit or something that you really don't know anything about, to a certain extent, yes, you do rely on the exchange agent or the tax credit attorney that's sending you this information to put on your settlement statement. But if you really don't know if what they're asking you to do is kosher or not, consider getting things, make sure you're getting it in writing. Don't rely on a phone call. Have them send to you a direction, a letter that says, here's what I want you to do. And make sure you preserve that. Again, it may not protect you 100%, but it helps. It helps to build a little bit of a wall. All right. Just a few more strange little things. Okay. All right. So when I originally was doing this, I was going to put, what would, who do up there. And I thought, okay, we'll just keep him out of that for now. But, it does feed into having an ethical practice, right? You always should trust your gut instinct. If you're asked to do something and you just don't feel good about it, and you don't think it'd be something he would do, maybe you don't want to do it either, okay? A signatory to a transaction fails the ID verification process for a mobile notary service. Anybody had that happen yet? Yeah. And here's what probably happened. How many of you in here have forgotten the answer that you put for your security question and you gave the wrong one? And then you're like, crap, what did I answer? Maybe I don't remember what my first grade teacher's last name was. It happens, right? So just the fact that they failed doesn't necessarily mean it's fraud, right? It doesn't. I get that. But when they call and say, this is just ridiculous, I can't get through this, can I just use my notary? All right. Well, that depends, okay? In this day and age of fraud and document fraud being greater probably than it's ever been, the whole point of using a approved notary service is to protect you and your clients from being a victim of a fraud situation. All of any underwriter that you work with, whatever process that we have in place, it's there because we're trying to protect you guys. If you know the person, you may not have to go through all the hoops, okay? Yes, those are our requirements. Yes, you should follow those, but they're there to address when you don't know the person, right? So if you know them, then maybe you could be okay with them using their notary. Even if it doesn't meet the underwriter's requirements, you know who it is. You're familiar with this person. This is the 18th closing you've done with them, and they just happen to be somewhere else. The reasoning behind our requirements is for protection in the event it's somebody you don't know, right? If you know them, we have a little wiggle room. So if you get into that scenario, reach out to your underwriter and just say, hey, this is happening, but it's so-and-so who I've done all these closings with, and I know them, and I know this isn't a fraud. I know that's them involved. Can't we just go forward? And you're probably okay. Anybody heard this one? The signatory is overseas and just really does not have time to get to the U.S. Embassy. It's 6 hours away, and it's going to cost them $5,000 for the appointment. They just can't do it. So a realtor says, it's okay, really, I swear, I know these people. Let them just go to a local notary. I promise it's okay. No, that may be okay, right? But if you don't necessarily trust your realtor, and that's probably a smart thing, what else could you possibly do in that scenario, right? Well, what about the Hague Convention? So I kind of just dig, I'm a history buff. I dig the fact that we get to call out like this really old legal convention, if you will, and say that if they're a country that signed off on the Hague Convention, then part of that really old legal agreement amongst a ton of countries was done so that you could use a notary in another country and we would accept it. One of the reasons that we have the U.S. Embassy thing in place is because we are not experts on the notary laws in every country in the world. And we don't want to be. And we don't want y'all having to go to Google. And I'm certainly relying on Wikipedia because we all know how accurate Wikipedia is about what the notary laws of a specific country are, right? So we put these requirements in place, again, for your protection, your client's protection. If they're in a country that signed off on the Hague Convention, then we can rely on their partnership, their joinder in that convention, and we can accept a notary from that state. And that's when they go get an apostille, and that puts them in compliance with the Hague Convention, and their documents can be signed. Okay? It's awesome. Now, Canada, our dear northern neighbor, was not a member of the Hague Convention. And honestly, I really don't know, but somewhere along the way, Canada apparently ticked off some people high up in Fidelity. I don't know. And for a long time, we were not allowed to accept Canadian notaries because of that, right? So then they joined the Hague Convention and we're like, yay, this is good. Now we can take Canadian notaries. Now we're told that the apostille process in Canada is just obscenely expensive and nobody's going to do it. And we don't care about the Hague Convention. We're not going to do that. Okay, fine. We'll make a way to work, but the point is that hopefully the U.S. Embassy doesn't have to be the be all end all to get you where you need to be. Now, title shows that a single female holds title to the property. As the closing is being worked up, you overhear one of your staff members say to a coworker, "Did she ever get her Vegas wedding annulled?" Everyone at church was so scandalized when we saw those pictures on Facebook. Okay. All right. Now, would that be a problem for you guys? Right? She's not said a word about being married. There's no change on her driver's license. But now, you heard this, right? Now, we don't expect y'all to be detectives. We really don't. We've never said, you got to get a copy of a marriage certificate at a closing to prove somebody's married. Vice versa, we're not saying you got to get something to prove they're not married, right? But your staff has a little knowledge and you overheard it. So now, if you know, right? Okay, so now you got to ask that question. So, is that rumor going around? You're married? Any truth to that? You got to document. You got to protect yourself, right? You got to ask the question. Most of us have forms that say, when they're signing their seller's affidavit or their buyer's affidavit and they mark off their marital status. You can probably rely on that, but you got to address it somehow. If you don't have that kind of documentation in your affidavit and you hear something like that, add it in. There you go. All right. This is one that I feel like a lot of us have from time to time. One of your very good friends comes and asks you for help in selling his mother's home. He has a power of attorney that appoints him as attorney in fact, and he tells you that he needs to sell the house to help pay for fees associated with putting mom into a memory care facility. She has early onset dementia. You know this family very well and are aware that one of the siblings has told everyone who will listen over the years that she will be so proud to live in her family's ancestral home one day. Now, he's asking you to sell it. He's using the power of attorney, and he's told you that mom obviously has some mental incapacity issues. That's your buddy, right? What do you do? There's a whole host of potential issues there, right? It doesn't mean you can't make this transaction happen, right? But you've got to take the steps to protect yourself and protect the purchaser against potential for the whole transaction to be unwound, right? In theory, what he's saying he's doing is admirable. And quite frankly, what a lot of us in this room have faced or will face over the next few years. Selling that property to pay for her care, that's facts. I mean, that needs to be done, right? Just because the sibling expected to get the property doesn't mean it's going to happen. So, but you got to stop and look into it, right? Okay, he got appointed power of attorney. Was that a popular decision in the family? Is there some strife? We had a claim years ago because a very similar situation, daughter had been appointed power of attorney. Mom had a few pieces of property. She sold, and in this particular case, it wasn't a family home, it was a commercial piece of property. She sold the property using the POA. Funds supposedly went to take care of mom's care. They were putting mom in a nursing home. 3 months after the closing, brother shows up, and brother files a lawsuit. Brother alleges that the power of attorney was obtained fraudulently and there was undue influence involved. And his allegation was that that commercial property had been purchased by mom for the very intent that when she passed away, the money from the tenants in that property were supposed to be her legacy to the brother and the sister. And that the sister sold the property without consulting with him, and that mom would never have agreed. His mom wanted that property to take care of brother and sister when mom was gone. So he filed the lawsuit. We had policy, so we were on the hook. There was a claim, and we were defending the title. And it was literally a brother and a sister just completely at odds. There really wasn't any evidence that there was, in fact, undue influence. But during the course of the next year, mom passed away, and then brother passed away before the lawsuit was completed. So sister was brother's only heir. So it was a tempest in a teapot, sadly, for all parties involved, but it cost the title company and others quite a bit of attorney's fees to address something like that. Those are the things you kind of have to factor through when you're looking at the impact of whether or not there is possibly some undue influence. Maybe there's something going on. And even though this is your friend, you still have to step back and look through all of those and consider whether or not, again, are you in the gray? It's not black and white. If it's in the gray and you're listening to your gut, you're probably going to make the right decision. Even if the decision that you make is to go forward with something that's possibly not, we'll call it proper. It doesn't mean you made the bad decision, right? It just means that before you make that decision, you ran through all the scenarios. You didn't react in anger and frustration. And let's face it, in the customer service world that we all live in, you're going to have a lot of that. Either somebody's going to be angry at you or you're going to be angry at them because it's the 15th time today they've called to say, have you got this scheduled yet? We can't afford to react in that. We have to take that moment to step back and take a breath and then make that next decision. If you do that, if you weigh it all out carefully and you make the decision, then you live with the decision. Tron has told me over the years numerous times that no one ever gets fired for making the decision. They get fired for not making the decision, right? And sometimes when you don't make a decision long enough, you've made the decision because it's already happened, whether you actively participated or not. So if I leave you guys with nothing else today, I will say this. Again, the underwriters, we're your judgment-free zone. If you are in one of these scenarios and you don't know what to do and you don't know what the right thing is to do, call us, bounce it off of us. Chances are we have heard it, seen it, been involved in it. The longer that I do this, y'all, I will never say that I will never do something because it's come back to haunt me more than once. I will never say that something just cannot be done. Because it can. We'll figure out a way. I've had to learn the hard way on some of these things, but we're a resource. And honestly, sometimes if you know the right decision is to say no and you don't want it to come from you, we'll take it. I've got lots of bus marks on my back. I'm okay for the bus to run over me if it helps you get to where you need to be. And I know Darren will be the same. So my point again in all this is we're all in this together. Ethics presentations should not make you feel terrible and should not make you feel like you have done anything wrong. The reason I think that whether it's your CE, your CLE, your governing board wants you to have those ethics credits every year, is that it's helpful to make you step back and remember that, again, your customers come to you because you're the expert. They're dependent upon you. And even though sometimes the customers are the ones that are asking you to take the unethical action, you have to be able to separate yourself from that and remember what all those consequences and the fallout might be, and what you can live with and what you cannot live with. And then you go home and drink, because that's what it makes us all want to do. So hopefully you found some of this helpful and useful. If nothing else, it just lets you know that you are not alone in the universe. And with that, I will say thank y'all very much.
About, again, you have already paid for, I believe, the Lost Canyon golf cart rides this afternoon. So the way I understand it is you can actually report to the top of the rock for those, tell them where you're with the Land Title Association. They will go ahead and let you process that. So that starts anytime after 2:30 today, whenever we're done with the continuing ed, in between that time break that you have that and the president's reception and the banquet. Reminder also that there is a women's title, what I kind of call a luncheon mimosa immediately following the continuing education this afternoon. It is going to be in the boardroom at the end of this hall. It is an